Well, good morning, good afternoon, and good evening, wherever you are. We are just waiting for the judge to start the feed for Chad Daybell's motion hearing on whether John Pryor will be allowed to step aside as attorney. Seems like on the day before, very late in the evening, I believe it was, prosecution seems to, rumor has it, actually, I haven't seen it because it's not on the website yet, but rumor has it the prosecution has made an objection. See, and I can see why. It's going to delay things again. So, hello everyone. Mousy, Commander, Liam, Craven, Rocket Couch, Charlie. Hey Alice, how are you? It is nice to see everybody. This is a little unusual to be up and online this early. It's going to be an early week. We've got a few things going. This week. We're going to be doing the Cody Awards on Sunday morning pretty early, 9 a.m. Eastern Time. That would be 9 p.m. if you're in Australia near Perth. And it would be lunchtime about a little past lunchtime, maybe 2 o'clock in the afternoon if you're in the UK. Was that an intentional Siri? Yeah, the Cody. Yeah, Coty. Yeah. You can just go look on the back of my community tab on what that stands for. There are 7 categories for nomination this year. So if you haven't voted, please go and vote. And let's just get our banner up there. Let me just check the feed again for Judge Boyce. Judge Stephen Boyce. I like this judge, actually. He does his own feed. He's the one who wants to control how things will go, what goes out. What is wrong with this lawyer? This lawyer is not certified for death penalty cases. Okay, and the thing is, if it goes with a public defender, they have to actually use one that is death penalty certified. You have to have at least 10 cases, I believe, in Idaho that were death penalty, of that caliber, to be certified in the public defender's office for it. Apparently, Chad Daybell was declared indigent over a year ago. And apparently, John Pryor actually owns Chad Daybell's house in order to pay for his lawyer's bill. He stayed with him all this time. But I think the prosecution would have a good objection as to why they didn't say anything sooner. They waited till now. They've known it was a death penalty case. They were trying to have it not be one, and they filed motions on it, which were denied, but they weren't guaranteed, So we'll see. All right. They said 12 o'clock, but I don't see anything on the judge's feed yet. I keep refreshing, and it's not there yet. I'm checking the other feeds, and nobody has it yet because, these things never start on time. It is supposed to start at 10 a.m. in Rexburg, Idaho, over there in Madison County Courthouse of Judge Boyce. Okay. And the notification did go to the prison too, so I do believe Chad Daybell will be there. I know John Pryor will, and I'm pretty sure the prosecution will too. The judge ordered everything to be unsealed because originally it was filed under seal. It was unsealed in public interest, the judge said, and ordered the hearing for today. Boom, just like that. So we'll see. Chad Daybell deserves the best attorney he can get. But then again, a new attorney coming on at this late of the game, John Pryor's been representing him from the start. That's a lot to catch up on. But John Pryor seems to think that he can't be ready for a death penalty case, even if you work 24 hours, 7 days a week for months. I want to know what he's been doing. I want to know what he's been doing. A man who can't find the button saying ain't so. I don't know. You see, the judge, I don't know. The judge doesn't actually press the button himself. I think he has a whole team. Yeah. No, John Pryor. Pryor, not Cryer. That would be funny, Craven. Like, I like John Cryer. I don't think I'd want him as a lawyer, but yeah. I don't think they forgot. I don't think they would do that. Nope. Nope, the other feeds are dead too, people. Like, I'm looking, they don't have it either. Except for them talking the way I'm talking, or they have better pictures, though. You just get me. I did absolutely no work for this stream whatsoever, except for create the stream. Typical streamers, you just can't start on time. Court streams, I mean. Yes, court ones. Yeah. I'm often late myself. I think it is something that streamers we just do. I don't know. Time is relative. Yeah, he can't handle a capital punishment case. He should have withdrawn when they separated the cases, because at that point, he was still on for the death penalty. Only Lori Vallow got released from the death penalty. Maybe if more men had teams, there'd be more satisfied women. You're funny, Liam. I hope you all have had your cuppas and you have snacks, because when we do this, remember, I won't talk during the hearing. I will wait for the breaks in between. I want you to hear it just as I hear it and just as it's going out. We could all talk about it later. I don't believe in all that over talking, injecting, whatever. You can ask questions and I can get to them after. If you want to jot them in the chat with my name, I will get to them when there is a break in the coverage. But I'm pretty quiet while the play-by-play is going on, because I want to hear every word too. I decided to get these on record because we're going to cover this trial now that Judge Boyce has said that all of the hearings and the trial will be available through his own web, so that he can control what goes out to the media. And we've used his site before for other hearings. And it's not too bad a feed. I mean, it sometimes the audio in these feeds is not as good. But I'll keep it up as high as I can, Well, let's go. Come on, Judgy. I hope he's not going to do the whole thing and then put it up later for us. Like he said, live. So live is like when court starts, right? Over talking is the only thing I'm good at, though. Well, this thing, it's a good thing you're not up here during the hearing streams. I don't know. I'm wondering what prompted Pryor to do this now. Is this like trying to get the trial delayed again? Currently taking volunteers. Okay, there, quiz. Hello. Good morning, sir, or good afternoon. Happy lunchtime. I have both installed. Okay. Well, I'm glad you're all amusing yourself in the chat. Hello, Victoria. Welcome. Carrie Ann, it's nice to see you. uh, yeah. So, there's a lot of other updates too. I think later on tonight or tomorrow, depending on if the voice holds out, we've got there was a ruling on the DNA in Coburg, and there is also some information in regards to the TikTok psychic. The Guilford, the Schofield and Gilliard case. Yeah, we're going to track down a little bit more on Courtney Clenny. There's stuff going on there. And also, I've been researching some more into an unsolved murder. No charges yet. Shanquilla Robinson. Still nothing. But we had the anniversary a while ago. Her birthday was just a week or so ago. It prompted me to look into some stuff. So we got some updates still. We got so much going on. A Reuben. I like that. With sauerkraut. I was hoping to be amused by a man in a black robe, so I'm having to make it to do it by myself. I'm so sorry. Hopefully he's going to amuse us shortly. Like, where is he? Oh, George. Oh, here we go. All right, hold on. Here it's coming. He has popped it up. Hold on. It's loading. And let's get this up here. Let's make sure.
A objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copies of that to
I'm going to
counsel.
just tell me you can hear it nice and loud.
Relevance to today's proceedings, so let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to counsel today.
Okay, thank you. And they're doing construction right through the doorway here, so counsel could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here. Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today?
I will, Your Honor.
Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit argument in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well and that I should probably, and is my voice at this point acceptable, Madam Clerk, in terms of the tone? It's not washing out?
Yeah, that's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors, and got the idea of maybe reaching out to out-of-state attorneys, and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So
Right, and that's correct, Judge.
this is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand? But when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. So obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, you know, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue, because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in a public proceeding. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security while Mr. Daybell is here. We will close this portion of the proceedings, and also for the bailiffs, if you could just make sure no one's within earshot of the a doorway as well, to make sure it's not carrying through on the microphones. And I appreciate your accommodating that. We'll also, of course, stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
Okay. Well. Looks like we're going to be waiting a little bit. I am going to wait because I think it's not going to take that long for him to say he has tried to get a mitigation specialist, but because there's no funds, he can't pay for one. I'm sure there's going to be a bit of a song in it. You know, let me just look into my little crystal ball here of common sense. If the man says in his brief that it would take him 24 hours a day, 7 days a week for the next 5 to 6 months to be ready for this trial, and he says that in a brief that he submitted under seal to the court, and then comes into the courtroom and says, oh yeah, I can be ready, I don't think the judge believes him. I think the judge is asking very poignant questions to make sure that Chad Daybell's rights are protected, because this whole thing could just go to appeal just based on this. Just based on the fact that what he said in the courtroom was different than what he said in his brief. It's ridiculous. I think the court is going to allow him to leave, and he's going to give a a court-appointed death penalty registered attorney, at least one or two, and he's requesting two, Chad Daybell, because that would be the mitigation experts. That would be the whole thing in place. They will know what to do. And I will bet that there's going to be another delay in the trial. We will not have a trial in 4 months as anticipated. We will have a trial in 6 to 8 months. That is my little bear crystal ball. What do you guys think? Maybe I'll put up a poll. Let's put up a poll. Will Judge Boyce allow prior to vacate? Yeah, vacate. That's a good word. Yes. Or no. Let's see. We'll run a couple of polls. Let's see what happens. Let's see how good we all are at. I just don't think this is going the way John Pryor thought. You know, they've done plenty of stall tactics as it was. They tried to control how the prosecution would do their case. That got denied. They tried to control the death penalty, saying, well, Lori didn't have to face it. Why should he? Like, that was different. That was technicality that got her off. Well, the prosecution was going to go for the death penalty for her, too. These are egregious crimes. What happened to those bodies alone? I know. Based on what I think. So you think because of his conflicting story, he's going to make him stay on the case? See, I don't know if he will take the risk for immediate appeal. To me, I think that's a really big risk for having whatever the verdict is appealed right away, just based on this issue. Who the damn lawyer is. That's what the judge has to think about too. I wonder if he's allowed to actually leave Pryor on there with no pay, because he said he would work for free. I mean, he actually told the judge that. I wonder if he can give him a court-appointed attorney to work with him. You know, we're talking about court here, Craven. Not that. I think, Carrie Ann, that would make sense. I just wonder what the legality is there. And I've been Googling, you know, while he was talking, I was Googling, and I could not find a statute in Idaho that allowed an attorney to just work for free while a public defender paid by the court, the state rather, did the work. He can, but it's silly. Well, thank you, Tsunami. That's in Idaho? Yeah. You know of some statute that you might be able to point me to? Because I'd really like to check that out. It's fascinating to me if they can. Boy, would that help a lot of different cases, you know? Yeah, I wonder too, Carrie, what her question in the chat. And what has he been up to this whole time? Like, he's had since 2021 to be working on this same case. He even sat through the whole Vallow trial. He knows the evidence. He knows what he's up against. He knows the prosecution style. He's got the same prosecutors, Rob Wood. He knows what they're going to do. The whole case has been laid out before him and in front of a jury. He saw the jury's reaction to it. He knows what to do. Like, unless he was sitting in that courtroom not paying attention, he's got a better idea of how to run this case than most lawyers would, just based on sitting through the Vallow trial. Don't you think? Or am I just like being a little off base here? That just makes common sense to me. It should be ready to go. We got court in four months, right? Isn't the end of April when he starts, or is it June? Like it's soon. Like it's only a few months away. this is going to be something. Well, most of you think that he's not going to let him leave. I mean, if you get a lawyer with all that history that's willing to work for free, why not make him? In like, what was it? Rocky Couch said he kept calling him Judge instead of Your Honor. Maybe he'll get back at him by making him work for free for the next 6 months. I don't know. But he really has to take into consideration what is going to be the best to protect Chad Daybell's rights to a fair trial, to the best defense that he can get in a fair trial. But even Chad Daybell really doesn't want, there's conflicting information there. He said he doesn't want him to leave. Then he said he wants him to leave because he wants him to. I wonder if they can get John Pryor to sign to be a public defender, to accept the fees of a public defender, if he could stay on the case, and then they get just one death penalty attorney to work with him. That way they have all the benefit of an attorney who's been there the whole time, able to help the death penalty attorney and get the specialist that they need. And then Chad Daybell's rights are all taken care of. I wonder if that's going to be a solution. That much time for a good defense, removing him adds another couple. I hope not a couple of years. But I'm thinking that solution, if it's in the law to be able to do and within the judge's ability to do so, that makes common sense to me. But I'm not a lawyer. I'm just a bear. I'm just a woman named Bear with a mic. In a lot of opinion about this stuff, apparently. Hello. Oh, hi, Mark. How are you? Nice to see you in the day. I heard Chad actually has an attorney in his family. His cousin Vinny. Really? You're just cracking jokes, aren't you, Kraft? Yeah, Crave, are you just cracking jokes? Because, like, his cousin Vinny, that was an actual very funny movie. I love that movie. It was very funny. Joe Pesci did a great job as the ridiculous lawyer. Wouldn't that need a sign off from the state? I do believe it would, Liam. And the state does not want John Pryor to be able to vacate. They don't want to delay. It's rumored that they're the ones who filed the objection, although I haven't seen it yet. As soon as I get my hands on it, you'll all see it. But Idaho does have this case up is public. Now, in the beginning, John Pryor's motion to leave was under seal, and the judge unsealed it right away because he said this was absolutely of public interest and there was no reason to seal it. There was nothing private in it or prejudicial. In a day, say what? Oh, that's right. I'm sorry, Mark. That's right. Oh my God, it's like really late. Why are you doing up so late? Well, I'm honored you're here. Yeah. This is early for me. I'm not usually here at all. Like, not until your morning. Yeah. Well, we're covering the Chad Daybell hearing, but they went private because John Pryor was asked the question on whether or not he would have a mitigation expert should Chad Daybell be convicted. Would he be prepared in his case with a mitigation expert to cover the requirement in a death penalty case? Now, that's a requirement in the death penalty case. As Chad Daybell's lawyer in a death penalty case since 2021, you would think John Pryor has made those arrangements already. We're talking about a trial that's a couple of months away. Liam, I did not try to vacate without good cause. I did not. Tommy Whistle has entered. I'm very happy now. I'm very happy now. I'm hoping my signal is staying strong. I hope I'm not roboting at any time. I do see the bar moving a little bit, and I don't like it. I hate that. I really do. Well, they are not up yet. No. No, it's currently still in a break. Oh, see? Let's just edit. Yep, still in a break. They just don't want to hang with us. Oh, I'm coming through strong. Thank you, Mark. Hopefully it's not too loud. I'm hoping my voice is a little bit better. It's been so ragged. I've been trying to rest in between. I did not stream last night, even though I've got a ton of stuff to cover with you guys. A ton of updates. So you're actually up early at 1:34. So you just got up. Wow, that's really early to get up. Like, Yeah, Carrie Ann, that's a good point. You can't imagine that someone up and coming, like a really good lawyer, but then again, somebody up and coming wouldn't have the experience or the cases to qualify as a death penalty attorney in the state. Idaho has a ruling about that. I think it's like, if from what I read, I think they have to have at least 10 really federal level cases like that. It is a good date night movie. I agree, Carrie. And my cousin Vinny was great. It really was. I do too, Mark. I can actually relate to that. I have very strange sleeping patterns myself. And that's it. Like, especially when I've been under the weather the last couple of weeks, and I could only sleep an hour to 2 hours at a time. I would wake up like coughing fits, so I wasn't getting any REM sleep, and I was a very cranky bear, like very. But I just the last 2 days I was actually extended my cycle to like 5 hours, so I feel much better. You know what? Grits are really, really good when it's cold. Grits is a great warm thing to have. It's comfort food. I like cheese grits with lots of butter. Oh my God. Like, who's making grits? Who started the grits conversation? Oh my goodness. Now I'm hungry. They better come on with this. Like, I thought we'd be done this one by now. Well, 18 degrees in Georgia, Liz? Wow. You have porridge oats? Those are the fine ones, right? I make overnight oats a lot. That's where you don't have to cook the oatmeal. It's like it's on a raw food diet. And I actually do like overnight oats. My favorite is peanut butter. I put peanut butter and honey. You got 2 feet of snow, Liz? Carrie Ann, 2 feet of snow. I hope your pipes don't break, Liz. I know it's been a concern for a lot of people. It was only 17 degrees yesterday here. And I do have one pipe that goes out to where my washing is. That runs on the outside of the house, and I was worried about that one. We had to let a little drip go. Well, today it's actually up to 32. It's still below freezing, but it's not 17. Carrie Ann, Michigan, it's very cold in Michigan. Like, you got rough winters. I know. Oh, thank you for virtually sharing half your foot long with me, Shill. What did you order? Like, as long as there's no onions, like raw, I'm fine. Pickled onions, I'm great with. Raw, like, good. Yeah. That's a foot long. That's nice of you to share. I am hungry. I want to wait when this is over, then I'll have something to eat then. I'm just hoping it doesn't take too long for him to come back. Yeah, the lakes put a lot of moisture in the air, a lot more snow, a lot more ice. Yeah, Carrie, in Michigan, like you're just surrounded with just like winter. Oh, thank you, Shil. No onions. Okay, I'll take that half. Ooh. Thanks. I know, Liz. Like, can you imagine? I guess I guess you get used to it if you actually live there for any length of time. Rocket says last week we had negative 50-degree day. We got an alert not to use too much power so that the powered lines don't go out. I saw that, Canada, right? Yes. And they were saying because of don't choose your electric heaters, don't charge your electric cars. Like, I read that. And I was like, everything's going to freeze over. They're telling them, like, don't be warm, people. Like, don't use your space heaters, your room heaters. They didn't want the power grid to go out. I know, Mark, you have summer there. What is it hot there? Was it hot there today? Or yesterday? Yes, or today? You're in the future. What's your temperature? Yeah. And Meow is vacation in a beautiful island, a beautiful place. Yeah. I bet you it's warm there. Beautiful. Hopefully a lovely breeze. Winnipeg was the top 5 coldest cities worldwide. I believe it. Nope. This week we should be pretty good. It was like 30 degrees Celsius. 30 degrees Celsius. What's that? That's like about 75, 80, right? What is that? Like, Let's do the math. $86. Very good. Okay. 30 Celsius is 86. Thank you very much. Around 90 degrees, Craven. Okay, you guys are good with the math. Thank you. Thank you. Yeah, Rocket. I remember someone posted it and I read it because I know a lot of you live there, like Shil and Ponchi, yourself, quite a few Canadians around. Yep. That sounds like lovely weather, Mark. It's not too hot. I don't think your roads aren't gonna melt. I know it does get very hot there in the summer. Liz, I'm only 5 foot, and whenever I have to buy thermals, it's an issue because I always end up having to hem them. Because they go to your ankle, right? But like you don't want them sagging like everywhere. You want them to fit like snug, So I always end up cutting the cuff off and then cutting them and then reapplying the cuff so that they fit right. I can never get them short enough. Right, a snug fit is best when you're talking thermals because it's a layer. You don't want them bagging at the knees and everything. Like so I know like you short girls, get a good tailor or learn how to really sew like really well because we're gonna be doing it all the time. Yeah, but it's too bulky. It's too bulky, Liam. I know what you mean, but that's too bulky. And plus, I don't use, I have cotton, like the cotton ones, but I also have the silky ones that I really like too. The ones like ski wear. I like those also. And they just don't like turn up very well. They don't stay, and it's just, no, it's too bulky. It makes it too bulky for getting your boots on and stuff, like around the ankle. Yeah. Mm. Well, now that we know it's cold and we're all hungry, in some places it's nice and warm, which is good. You know, I'm envious. On the other side of the world, it's a little bit warmer. Yeah. It does sound cold though, Sheila. I mean, Winnipeg is freezing. All the pictures I see, you guys are all covered up in snow and ice. Like there's nothing. Yeah, it's all white. It's white, white, white. Now it did snow here, but not a lot. Not like you guys get. And it was quite cold. But luckily there was nowhere I needed to go in it. Yeah, all innerwear, Liz. You want it to be snug. Exactly. Yeah. Oh, come on, dude. Like, how long is John Pryor? You know, the way he was talking in circles about the other issue, I mean, this could take a long time. I wonder if we should have taken a break. Like, I don't know. I'm just kidding. Like, Let me see. What should I put a poll up about? We've got the majority of you believe that John Pryor is not going to be let off of here. Okay. Let me give you another poll. Snow on the beaches? You mean like at Brighton Beach, Mark? In the UK? Wow. Unheard of. I've never seen snow on the beaches. No. Wow. What is John Pryor's true agenda? I think court delay. Yeah. Okay, here's another one. How about, will the judge assign a lawyer to work with Pryor on this case? I wonder, what are the odds of that? What do you guys think? That's the only beach I know of. That's why I mentioned that one, Mark. Like, mostly because I have friends that live there. I had friends who vacationed there. And also because Ren used to do a lot of his buska, his buskering there, you know. And I follow Ren. Like, I think that young man is quite talented. It does sound like a fancy drink, doesn't it, Craven? He said snow on the beach sounds like some sort of pina colada alternative. I agree. It does sound like a drink, a summery kind of drink. Snow on the beach. The yes is all. I did, didn't I? Oh, I'm sorry, Dan. Like, I kind of skewed it, didn't I, Rocky? Like, subliminally, I just, like, kind of skewed it by making the yes in capital and the no not. Oh, no. That was not intended. What is it you don't think is getting dropped? Oh, you mean to get the death penalty dropped? I don't believe, you see, that motion was filed and denied. So I don't think unless the prosecution willingly comes forward, state comes forward and says they'll just remove it. I wonder if that could be the negotiation. That would be probably the only thing that John Pryor has done that would actually be worthy of whatever money he did get paid. If he actually got the death penalty dropped because he threatened to leave the case and everything get all messed up. As a matter of fact, he did wait until after the motion was denied, didn't he? You might be onto something here. This is shenanigans, lawyer shenanigans for sure. Oh, Lori didn't get it because she's mentally ill and it took months to stabilize her for trial. Chad has no mental illness diagnosis. Yes, it was a technicality. It was in punishment to the state for untimely filings that had to be done while she was being considered mentally health or anything. There were timings that they needed to meet that they missed. And that's why the judge pulled it, because they didn't meet their filing dates. But actually, I don't know how much her mental illness actually played into it, because she did get cleared and competent for trial eventually, which wouldn't play into it. I think Pryor thinks he's playing a good game, but the judge holds the power to say no. Ma'am, that's right, Tsunami. And I don't think John Pryor was ready for that. The judge was well prepared. He asked very good questions. He wants to protect the integrity of the trial. He wants to make sure the appeal options are not great. No judge likes to get overturned. No judge wants to hold the trial for just to have it tossed aside. Okay, his job is to make sure that Chad Daybell gets a fair trial and that justice is served. That is the fair playing ground that he works on all the time. He's right there in the middle, keeping control of it, and he's asking the right questions. And he's making John Pryor work for this. I think he knows what's up. And I think he hopes that the state negotiates. And I think that might be what's going on in the back room. I can't wait till they come back now. That was a horrible punishment to the state to remove the death penalty. It wasn't fair to the victims or the family. They were upset by it because the children lost their lives. Tammy Daybell lost her life. So many people involved in this case lost their lives. We all know the bodies are everywhere, No, you didn't miss the entire thing. They're in private right now because John Pryor wouldn't answer in public whether he had a mitigation expert for if and when Chad Daybell would be convicted. And they're discussing whether or not he's staying on the case or not. And the judge is asking very poignant questions. But John Pryor said that was strategy, and he wouldn't discuss it in open court. They had to do closed court, so they cleared the room. They went behind the doors. We're on a mini break while they do all of this and figure out whether John Pryor's staying on the case or not. It doesn't sound like the judge is leaning towards letting him off. I think he sees it for what he is. And if you look at the beginning of the stream, you will actually hear John Pryor talking in circles about how he wants to stay on the case and he doesn't need to be paid, but that Chad wants him off because Chad says he deserves to be paid. And that in his brief, he said even if he worked 24 hours, 7 days a week, he could not be ready for this trial. And yet he just told the judge to his face he'd be ready to go. Am I wrong, Chad? I mean, that's what he said, right? I am prepared to go forward and I am ready to defend this case when we go to trial. Yeah. But in his motion, he said all the opposite. He said he wanted to get paid. Now he's saying he doesn't need to be paid. And he was talking in circles. I think Judge Boyce kind of could tell as he started asking very poignant questions about what he did do about getting an attorney and why, it's taking this long and blah, 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 blah. I'm just wondering what options are available to the judge to rectify this, whether he can put a death penalty certified attorney from the public defender's office on the case with him to protect Chad's rights. Hmm. Yeah, he says he's struggling. He says it's impossible. I mean, John Pryor just spoke in circles. Like, who knows? Like, he's the best talk out of both sides of your mouth lawyers I've heard in a while. I think someone in chat referred to him as a used car salesman, and you're pretty right on it. Yeah, is he a slime ball tsunami? I don't know. Like, I know he's been like working with Chad Daybell from the start. Like, but this is kind of real lawyering. Anyway, the popular consensus, Mandy, and I'd like to know what you think, is they are saying that they think he's doing all this just to get the death penalty dropped, to force the state to not want to have another delay, that they have the choice, either drop the death penalty or there's going to be another delay in trial. He said it was for financial reasons. Now he's saying it's not. He's saying it's because Chad needs a death penalty lawyer, which is true, because you have to have a mitigation expert and everything. Like, it's up to Chad if he decides not to. But if the public defender gets assigned, the state requires it to be a death penalty certified attorney based on the fact that it's a death penalty case. But that's only if it's a public defender and it's the state funds that are being used. That's the statute. Chad can decide to have anybody defend him he wants. And he chose John Pryor with the death penalty on the table all along. And John Pryor was not death certified, not in 2021 when they were hired him. What, Tsunami? Oh my goodness. You know what? Hit my DMs with that case. I need to know about this lawyer being like that. Wow. I had not heard anything about that, love. And I would like to look into it. It's a whole thing. Linda, it's a crime, covered his slimy past. You could link me to her channel or the case. That would be great. You can hit me on Twitter or in Discord or Instagram. Everything's listed in the description below. Well, they've known this was a death penalty case for years, so it makes no sense. Exactly, Mandy. They have known about it for years. He's been working with them for years. His affidavit says he could not be ready if he worked 24 hours, 7 days a week. And yet he just stood before the judge and said he was ready. Like talk about spinning your wheels. I mean, and then he said it like so many different ways, you know? Do you? Okay. I do feel a little bit better, Mandy. I've actually been able to sleep more than an hour or two. The coughing has stopped. Thank you. And you've been so sweet keeping up with me and sending me well wishes. I do appreciate it. Many of you have, and I do appreciate it. I really do. It did warm my heart every day. I have been very lax in getting back to a lot of people because I've really just been resting and keeping off. Plus, like, it's been a crazy week for updates. Tuesday was like insanity with everything going on. And we've only covered a couple of them so far. I think we covered Sarah Boone, we covered Murdaugh, and we covered Rex Harriman. But we still have Courtney Clenny, we still have Koberger, we still have Scientology, and we still have the TikTok psychic. All of this came down this week. Stuff that's going on that has to be, brought up to date. And I'm trying to get it to you. Where is my judge? Is he back yet? Nope, still on break. Yeah. Nope. Still. Yeah, there he is, still on break. I'll just leave it up there so we don't miss it, like, for sure. I thought I had it large though. Wait, why won't it? Oh, there it goes. There it goes. Better. All right. Whoa. As long as the email wasn't some kind of phishing garbage, most obvious since people usually know to be suspicious. Oh, you mean about the insurance thing? Oh, yeah. Bring in the dancers for intermission. I wish I had some. Are you volunteering, Charlie? I could use a couple dancers for this. Yeah. You know what? I know you have, Mandy. We've had some issues about voice, right? With not allowing Valo to be the cameras, although he is allowing them for Chad Daybell. He just wants to control it through his feed, which I don't mind. I mean, at least he's allowing the hearings and everything. But I do think, like you, I do agree he's very good at shifting through the BS. And he did ask some very good questions today. He did. Yep. Dancing. Oh, Mandy, thanks for bringing the legs. You don't like his nonchalance, but respect his due diligence. That's a good way to put it, Carrie-Anne. He does put a lot of people off by how casual he is about everything, and he's kind of like, eh. But he is very good about due diligence and covering every issue, okay, whether private or not, in like making sure that he protects the dates, the timelines, the issues, and keeps track of, like, he's very good that way. And he did act like, when it came to this motion, he asked some great questions, and I don't think John Pryor was prepared for that kind of pushback, actually. Yes, it has. Oh, thank you, Mark. I'm glad it's sounding better. I have been drinking a lot of green tea, honey and lemon, a lot of. Oh, I'm going to be quiet. Here we go. Look, oh, Judge is entering the room.
Thank you. Please be seated. All right, we're back on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today, because case law also lays out that a trial court's failure to conduct an inquiry into conflict will in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. I think from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has, in fact, done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance, asked, and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating. But in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid, I want off the case. Today what's being presented is no, I'm fine not getting paid, I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there could be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think
Ms. Blake, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case. And as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying, I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it, because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. in April, the state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed, and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for
Thank
the argument and response, Mr.
Judge,
Blake.
can I respond briefly?
I was going to allow your response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money, and I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized the
You've been on
workload.
a case for 2.5 years by yourself, and
I have.
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, And I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law and the way the law is written and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognized, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's gonna, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. And it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree the arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial, and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
And we are going to wait for him to come back with bated breath. Whole fireworks. Yo, Lindsay. Like, was that incredible or what? Lindsay was ready. Yeah, the state was ready. Lindsay Blake, I can't say enough about how prepared and well-spoken she is. Who was the other attorney that used to help defense? John Pryor. Oh gosh, there was somebody. Let me just let me see if I can find it for you. There was a guy. Was it Koch? I'm not sure. Oh. I'm trying to think. I know that Lori had 2, remember? Like, she hate too the whole time. We knew who they were. Oh, I'm not finding another name. I'm going to look into it though, Mindy. That's a good question because I know in the early filings, I'll bet you if I go back, and in my description, by the way, everyone, is the Idaho website where all the filings are, the ones that haven't been sealed are on for this case. It is a public record. They have transparency law for Idaho. You'll find Kohlberger there too. It also will tell you when hearings are and things like that, and it will give you the links. There's also a list on that page of the links to the YouTube channels for those that agree to actually permit cameras in the court. His name was Joe. No, it wasn't Crave. Stop it. Stop it, Crave. Facts only on these shows. Facts only. Knock it off. Their state seal is pretty cool. Yeah, we could put that up. Let me put the state seal up. There we go. We'll just. Oh, look at that. I'm bigger than the state seal. I don't know. I do not know. Does anyone want a link to come up? Like, I'll drop it if anybody wants to come up. I'm just wondering how long it's going to take him to go through. You know, he was taking notes the whole time that Lindsay Blake was speaking. He took several notes while she was talking, because she made valid points that they knew this was a death penalty case all along. It had been approached several times when they got their continuances and etc. Like, they knew he was indigent back in the end of 2022 before they went into 2023. They knew that he was indigent and that he qualified for a public defender, and yet they continued with his private attorney. And she makes a very valid point. At that point, when you continue with your private attorney, who you know is not death penalty certified, you are waiving your rights. He knew all along that he could have, at that point of indigency, gotten state-appointed attorneys that were death penalty certified. He was entitled to them, 2 of them, at that time. It would have been the burden of the court in the state to assign them. And then John Pryor wouldn't be wasting a year. Are you telling me he looked for a year for another attorney to work with him and no one would? And I'd say that sounds like a personal problem, because this is a high-profile case that's going to be televised. Even though Chad Daybell's going to jail, there's a lot of attorneys that would want in that room. Okay? We know he's not going to get off. The Vallow trial happened first. Her charges were less. She's away for life. He's not getting away with this. It's good unless there's like a miracle technicality or something that happens, you know. They have more evidence on him. The bodies were on his property. They can place him there. They couldn't her, and she's away for life. Yeah, no attorney can help him. Yeah. He's competent. The prosecutors are not saying he can't do the job. They're saying that this is some kind of what they're insinuating is that they had plenty of time to bring this issue forward, and this is just a disruption of justice to actually bring it this far, this close to the actual trial date when they knew all along. The unspoken issue here is that Daybell is convicted. He could make the issue of ineffective counsel. This should never have been allowed to go forward with Pryor. This is on the judge. Yes, you know what? All along, they should have had a hearing in the beginning. Instead of just like letting him just say he was going to go forward with Pryor, they should have laid out all the issues. You're right. But they do have protection in the fact that they knew it was a death penalty case all the time, and he chose to stay with Pryor. He would give an opportunity. Yes, the judge is using if and not when, but we all know it's when. Like, yeah. That is exactly what it looks like. And why do I keep losing the signal for that other channel? Eek. Eek, eek, eek. Oh. Am I roboting a little? Is it better now, Mark? Okay, what I'm going to do is I will go only with the StreamYard's chat so that I have less open. There we go. And hopefully that will keep the signal for a bit. Is it coming through better now, everyone? I hope. It's your robot, Mousy. I hope you didn't send me your robot. I wish you would take it back. It's like, I don't want your robot, Mousy. But I do know the signal. I did see the bar drop, so it could have just been a temporary thing. I think that I fixed it, hopefully. Nope, since it's a dental penalty, the appeals court will hold them to a stricter standard. I agree. I agree very much so, High Inquisitor. And it's you know what? And that is why in a death penalty case, regardless of what the verdict is, there's always an immediate appeal right. They don't need a reason. They're allowed to appeal immediately. This will get kicked back for that when a person's life is on trial. Just drop Pryor and get a new attorney. You know, it may be in his interest. They're going to have to make him, make the decision today. But the judge is going to come forward, and I do think we're looking at a continuance again. And I do think Pryor's out. Just the way he was whining alone at the judge, I don't think the judge has the confidence that he's prepared. Exactly, Liam. They're pirating my Wi-Fi. Yeah. He does, Liz. High Inquisitor is on it about it. And this is like in the United States, all death penalty cases are immediately appealed. Okay, once the verdict is in. It's like it's a given right because it is so serious. It does get reviewed. You think 2025, Mandy? Oish. Well, you know what? Boone got a new attorney and asked for a continuance, and she only got a couple of months. She only got till May, which I was happy to hear. Very happy to hear. I did that on Tuesday. May 3rd is the next status hearing, and then they've got a trial date of, I believe, May 13th now, Mandy, for Sarah Boone. And by the way, people, that was the 16th continuance. There were 15 prior continuances before Tuesday. She's on her 7th lawyer in 15 continuances. And the only one who's had more lawyers in the same period of time is that new case I just brought up last week that Shawnee Lynn Kroll is on his 9th attorney. I will give Sarah Boone some credit. She at least didn't threaten the lives or bodily harm to any of her attorneys, so there we go for that. She just had a lot of nasty things to say about them. But yeah, the Boone case has way less discovery than this one. This one has a lot of evidence, a lot. Yeah, I'm pretty sure you're probably, I can't put up another poll because I had to close the YouTube tab there to make sure the signal stays strong, and I want to keep it strong. But I do believe you're probably more towards 2025. You would be more correct than I. I'm hoping October of 2024, but we'll see. You could be right because, they want to give him the fairness, and they've got to give, if it's 2 brand new attorneys coming in, they've got to give them time to catch up. I'm wondering, Mandy, do you know what our speedy trial requirement is if it was a death penalty case and they didn't opt out? would they have to go to trial within 6 months? Because that may be the basis as to what the continuance will be. Because any new attorney coming on with a trial set date, even a speedy trial, would be about 6 months, right? Yeah, Liam, that was quite crazy, wasn't it? Yeah. 1 for October, December 2024, 2 for January to March 2025, 3 for March or later. Thank you. That's a good poll, everybody. Put your numbers in. I'm going to go. I want number 1. That's what I want. I don't know if that's what I'm going to get, but Mandy goes after March of 2025. He already waived. Oh, yeah, I know he already waived. I'm just saying if I use that calculation in my head of what speedy trial was, that would like be for that attorney. That might be what the judge would do a continuance on. I was just trying to come up with a way to formulate it. I know it doesn't apply here, High Inquisitor. It's already been waived. I'm using it as a calculation of how many months a new attorney would need to get up to speed. That what would be reasonable. Liz, I think you're right. He was talking in past tense and he did not seem very happy. And it sounded like he was on the verge of tears when he was speaking about what the prosecution had said. I kind of felt for him. Okay. Nothing yet. I don't know. There doesn't seem to be a vehicle. Whatever vehicle he had hoped for, I think he had hoped for a paid assistant, like a paid attorney that would qualify and he could stay. I do, because when he said there was no vehicle, he literally said when they came back, John Pryor said there's no vehicle to allow me to go forward the way he wanted to. Yeah, we know, like, I know that he's already waived all of his speedy trial. I get all that. That happened before the severance. That was one of the main reasons for the severance, was that one wanted a speedy trial, the other one was waiving for proper counsel. So that was one of the points that was used to sever the case. It is. I mean, I guess the longer they have, the better it is for preparation, but I'm sure they don't always have optimal time to prepare for a case. I'm just wondering if there's anything in the statute that would give them bare minimals. Yeah, get the trial done. Actually, Chad seems quite comfortable with all the delays. Like, because like the death penalty's there. When he's convicted, it's not just for life. It's actually to death. So it's this is way better than soap operas ever. Thank you, Carrie Ann, I think. He did say he was prepared. That's what John Pryor kept saying. But then he just said, like, then he said he would have to work 24/7 and still not be ready. And I think that the prosecution had every right to bring that up, the double speak that he was doing. Yep, he's just fighting to stay alive, High. You're absolutely right, Quiz. In the stakes are much higher. Hello, godless granny. We are waiting for the judge to come back and let us know if Chad Daybell is going to continue with John Pryor as his attorney or receive 2 new attorneys that are death penalty certified. from the public defender's office. And how long of a continuance we're looking at, and if there's going to be a trial in 2024 or even in 2025. There's been a lot of double speak on the side of the defense. It's quite interesting. True quiz. They don't like when people kill children in prison, do they? They do not. I mean, I'm sure they have to keep them on protective custody somehow. It is nice to see you here, Granny. I hope you're having a good day. And you're always welcome when I do these. Like, do you want me to drop you a link? You can come up. Do you know anything about what's going on? Because you can definitely come up. And when I cover this trial, you're welcome. Breaks in lunch anytime you want. Death row has a lot more security and restrictions. They do. They get a lot less time out and stuff, don't they? It's a much more secure, of course. Like, there's a really hardened criminals. Like, yeah. So, okay. So basically, besides me and Mandy, like, Mandy thinks after March of 2025, and I'm hoping the end of 2024. I didn't see many other votes, people. Actually, Liam and Shill actually voted with me, and Carrie Ann, all vote hoping. We're hoping the end of 2024, but we'll see. Oh, you'll come up if I get you John Cook's phone number? Yeah. Oh, he is Lori Vallow's counterpart, husband. He is Latter-day Saints cult-like guy who wrote all those books and kind of like turned Lori Daybell Vallow into like the religious zealot that she turned out to be, and actually helped her with all this premise about the kids being zombies and needed to ascend to a higher life. Basically, her marriage to him was the catalyst for why everybody died around them. His wife, her children, her ex-husband, her brother. Her brother died of natural causes, though. This is a horrible story, but this is part 2 of the Lori Vallow, Chad Daybell story. They were charged together, but early on, it got severed. After a while, Lori was going through some mental competency issues, and then she still wanted speedy trial, and Chad Daybell wanted continuances and wanted to waive speedy trial. And the death penalty was removed from Lori Vallow, but continued with Chad Daybell. The case was eventually separated and moved to a separate county and got a continuing so they could prepare, because it was a death penalty case. And here we are now with the same lawyer trying to leave that case because it's a death penalty case, even though he got it severed for that reason. Maybe, Mandy, maybe you will think it, like, turn him into a zombie so he doesn't know. I don't know. Yeah, Tommy did. Her brother Tammy died of natural causes until they found out that it was asphyxiation, and it could have been by a pillow. Yes. No, she didn't die of really natural causes, did she? Carrie Ann explains Chad Daybell as some cultish religious person who is avoiding accountability like a bill collector. Yes, exactly. So she was already an LDS zealot. Yes, she was. Yeah. And she started reading his books, and then Melanie introduced them, and he wanted to smash. So he told her they were married in past lives. Yes, he did. And then they got married in the eyes of Jesus somewhere else where nobody else knows, before they were married. Okay. And they started an illicit affair, and all of this started like happening. Yeah. The families were decimated, destroyed, killed Nobody needed to die for them to be together. Why don't they get a divorce like normal people? No, Tammy was the wife. Alex is the brother. Charles is the ex-husband. Um, yeah, he requested no autopsy. Yep, I remember, Sonomi. Lori wanted the money, so she couldn't get divorced. Same for Chad. It did, that came out in the trial, Lori Vallow trial. There was a lot of testimony about her taking her daughter's Social Security, banking the money for her son, even after. There were some charges put on her for that, actually, because she kept money after they were gone and moved it around. She was moving funds around illegally that were not hers. Yeah. She didn't look right. She did look a little money hungry there. And I have to tell you, every time I think about that case, it really kind of tears me up. The evidence that was displayed in that case was some of the most horrible stuff I've ever seen. I mean, I thought Letitia Stouch, the evidence there was hard. I really felt for, that boy, in what he went through, on what the condition and what they did to the bodies of the children in the Chad Daybell case is just absolutely abhorrent. Okay, looks like he's back.
All right, we've confirmed the live stream's begun again. We are back on the record on case CR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders they are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
Oh, yeah. Oh, there we go. Okay, so Pryor's talking to prosecution right now, and looks like our trial date is staying the same. Wow. All right. Let me take that down since that's not going to assist us anymore. All right, everyone. Like that was, I'm glad that we actually got together to go over that because that was something. That was quite pins and needles for a while for me. But I don't know about you guys, but I actually think that John Pryor actually did convince the judge that his motion to dismiss was his motion to leave the case was half-hearted and really was just trying to get another continuance in some way, because he literally came before the judge and said the exact opposite of what was in his motion repeatedly. And then Lindsay Blake actually called him out on it, and you could see Boyce was like also challenging him. But the deciding factor was whether Chad actually wanted him to leave the case or not. And Chad Daybell said he wanted him to stay. That's going to take a lot away from appeal. This is the third time, knowing it's a death penalty case, that Chad Daybell has been asked if he wanted to go forward with his private attorney, who is not death penalty certified, and he has chosen to stick with him. Boyce slapping the shit out of Daybell wasn't on my bingo card for today, but aren't you so glad we saw it, Mandy? I mean, I know we had issues with Boyce quite a while ago, especially at the beginning of this whole thing. But I have grown quite fond of him, actually. I have. I have. Okay. And I've learned to listen to his questions on where he's leaning. And he was quite prepared today. He was. When he said that it could go into 2025 or 2026, like years, I feel for him. Nobody wanted this case on the books for another 2 years. Nobody. You can't sit in jail for 4 years and then go to trial. Exactly, Quiz. He's got to take everything into consideration. And I think he did a good job of taking it all into consideration. The final thing was exactly the words of John Pryor and Chad Daybell. They both said they wanted to go forward together. And John Pryor didn't care if he got paid. And then, contrary to his affidavit, said, I will be ready for trial. I'm prepared. And I don't want a continuance. I think when he saw the writing on the wall, now he doesn't have a choice. All right, on that, thank you everybody for being here. We're going to wrap this up. I may be back tonight. If not tonight, then tomorrow. We've got plenty to cover for the rest of the week. Thank you for joining me for this. I do plan on covering this particular trial when it comes. Judge Boyce said he would control the release of all the hearings in the trial through his YouTube, and I plan to cover all of the hearings that are televised in or actually streamed in the trial as it goes. Thank you all for being here. I'll talk to you all soon. Don't forget to like, share, comment. Put some comments on that video. Keep me in the algorithm. You know, does he have the Bee Gees song "Staying Alive" on loop in prison? I don't know, Mark, but I don't know. It's too funny. Have a great afternoon, everybody. Oh, and new members from Mandy. Thank you so much for the 5 gifted members. For those of you that are not already in the Discord that have been gifted a membership, please, hit me up. Somehow through the socials, I will get you my Discord ID. I did put it in the chat. I will give it to you again, and let's get you all hooked up. Also, for members, there's a members only on the community tab that does have all the information there. Try that link. If it doesn't work, hit that friend request over to my Discord DM, and I'll get it right to you. And oh my gosh, right before I leave, Shill, really? Oh wow. Shill has just gifted another 10 memberships, and I don't have my YouTube up, so it's not telling me who. So I can't see it because it doesn't show me. Anyway, thank you, Shill. Thank you, Mandy. 2 of my supporters from day one for a very long time. Mandy's been with me since before, and Shill has been since the very beginning. And I thank you both, your support. I thank all of you for your support. But these two come through consistently, just even privately, on the support whenever they can. And it touches it really. I'm very touched right now. I think I'm a little emotional because I don't feel good, but thank you. And thank you all for being here today. That was great, especially something so last minute. All right. So whoever the 10 are, I'll have to go back on the YouTube channel and look later and see, You think you saw a bird coming from the judge? Yeah. Record, I think I did see him almost rolling his eyes a few times, but I don't know if you heard Record, but he denied it. Like, absolutely. Shill and Mandy, thank you so much again. Juju, I was laughing. I don't know. Yeah. I don't know. All right, I'm gonna go. Hopefully, I'll see you all tonight. To the 15 members, if you want in that Discord, you know what to do. I'll put up another community tab, but there is one members only there, and you'll be able to hit that link now that you're green. All right. So on that, I'm gonna say, check y'all later. Were you laughing? You felt it too? Yeah, like, you know what? It was nice to see. I think Mandy will agree. It was nice to see Boyce recognizing the shenanigans a little and pulling it up. And then he laid the whole groundwork as to why this is not going to be appealable, like why it is so. He really has only very limited choice that he could make in this position. And the deciding factors were, does Chad Daybell want to continue with a private attorney knowing he's not death penalty certified? And Chad Daybell's answer behind closed doors was yes. And that kind of like seals the deal, doesn't it? Dean John Pryor just needs to stay. He needs to stay. Once Chad Daybell said that was the end of it, because it is his decision. All right. See you all later. Either later tonight or tomorrow. Have a good one.